Hey everybody, Joel Bailey at Bailey Criminal Defense here today to take a brief moment to talk to you about immigration consequences with criminal convictions. The federal system handles immigration law, but a state court conviction of a crime can result in your deportation on the federal level. So if you're not a U.S. citizen, understanding the consequences of what you're pleading to and what may result from an immigration perspective is important. So let's talk a little bit about immigration. The federal immigration system has three different categories for persons in the United States of America. First is citizens. A U.S. citizen doesn't have to worry about immigration consequences. Once you've been naturalized as a U.S. citizen, you cannot be deported, so you're going to be okay with very, very certain exceptions to that. The other type of person in America is called a lawful permanent resident, and the third category is an undocumented alien. So this applies mostly to lawful permanent residents and undocumented aliens, meaning that those people are subject to deportation, exclusion, and removal from the country. So there are three different types of criminal convictions that can result in your deportation. The first is called an aggravated felony, and aggravated felonies are defined in a variety of different ways. There's over 120 aggravated felonies in the California Penal Code alone. They are specifically deportable, excludable. They can deny you various forms of relief that you would have if it weren't an aggravated felony. And they're also subject to more serious punishments if you try to return after being removed following an aggravated felony conviction. The second type of criminal conviction that can cause problems is called a crime of violence. Domestic violence convictions, often many of them are misdemeanors. Pretty much all felonies are considered crimes of violence and will result in your removal and deportation from the country. So those are all very serious. If a crime of violence defendant gets more than a year, it's automatically an aggravated felony and it falls into the other provisions we just discussed. And the third type of crime that can result in deportation or immigration issues is a crime of moral turpitude. This is defined in federal law with a variety of different ways in different cases, but it's generally considered a readiness to do evil, the intent to cause great bodily harm, the intent to defraud, or the intent to commit a theft with the ensuing intent to permanently deprive the owner of the property. Now that can be dissected a little bit, and we can play with that a bit to protect your immigration consequences. So who gets deported and for what? Now, a non-citizen defendant is deportable if they have at least 2 crimes of moral turpitude at any time after admission into the U.S., or 1 crime of moral turpitude if it's within 5 years of lawful admission or adjustment to lawful permanent resident status. So if you're within that 5-year window, it's just 1 crime of moral turpitude that fits into the category above, and you can be deported if you have 2 at any time. Even if you became a lawful permanent resident 30 years ago, you can be deported. So there are a variety of different things to look for and to watch for in a criminal case if you're facing a criminal conviction and you are not a U.S. citizen. I've been doing this for 22 years. I try to keep up on the law as soon as it happens because this law does change. This area of law changes rather frequently. So if you have any questions about your immigration consequences, please give me a call. My name is Joel Bailey at Bailey Criminal Defense, 760-643-4025. The consultation is free. I have payment programs. Yo hablo español y la consulta es gratis. Thanks a lot and have a great day.